Is there anything in your experience or your studies that would lead you to think that there's a reason to consider what's going on in somebody's head as something we ought to worry about if we decide they're guilty or innocent?
Well, yeah, because what we think is that mental states, like did this person intend what he did? Was he suffering from a major mental disorder when he did it? These are things that are going on in someone's head. So if neuroscience, better understanding of the brain, can help us understand those psychological phenomena better, that would be a great help to the law.
But do they?
Not yet. And in principle, a lot of people think they never will. A lot of people think they're ready for prime time now. My view is somewhere in between. I think that the neuroscience of the future may very well help us in many different ways to have more sound legal policy, to help us adjudicate individual cases more fairly, to help the legal system work more efficiently and things like that. But I think that's in the future, and only the future of the scientific developments will let us see how it will unfold. There's something else worth saying. If there's a difference between how the brain looks and how the behavior looks, for legal purposes, you always have to believe the behavior. Because, let me give the analogy of back pain, and hold aside someone who is malingering for a minute. Here's what we know. There are people who have miserable looking backs on X-ray or on MRI, but who have no pain.
Right.
Then there are people who have great looking backs and really have pain.
Or you have something wrong with your back that's clear to see in an MRI scan, but you function okay.
Right.
So should you get an operation on the basis of the scan or on how you function?
Right.
So now let's apply that to the courtroom.
Right.
And say this person has wiring that's all screwed up in the pictures, but they have behaved normally up until now, and then they took a week to figure out how to kill their wife. So should we treat them as though they're damaged and let them off, or should we treat them on the basis of the behavior? Is that sort of the area we're talking about?
That is precisely right. And since the legal criteria are all, and I can define this for you in a second, are all folk psychological. All legal criteria are mental and behavioral. So think about murder. Murder is intentional killing behavior. I shoot you, I knife you, with the purpose to kill. That's all behavior, behavior and mental states. And so under those conditions, we've got to believe the behavior because that's what the legal criteria are. The legal criteria are not brain criteria. They're not biological criteria. They're folk psychological criteria, criteria that are dependent on the kind of creature, you and me, you and I, you and I.
The grammar police will get you for that.
I know, my goodness, we're a professor as well. Creatures like who act for reasons. I mean, if we were to ask, why is Alan Alda sitting here today? No one would provide a story about his brain and nervous system. Everyone would say, well, he desires to have a very good show. He believes that if he interviews Stephen Morse, it might go better, and he formed the intention to be here, and here he is.
Right. And no one would say it was because I was crazy.
No, I don't think so. Well, those who don't like my views might say so.
But you raise an interesting point. It seems to me that just as an observer on the outside,
Right.
that if the justice system has been working all these centuries on folk criteria, and now we have a new science that can actually look inside the head of a great number of people and figure out what's going on when they perform actions, when they actually engage in behavior. Isn't science in a position to inform those folk criteria and make them a little better than ordinary folk criteria? In other words, a little more knowledgeable, more informed. What do you think?
Oh, I think that's an extremely good point. It goes back to what I said earlier about the potential contribution. You can't do that now, but it could in the future. But here you want to make a distinction. The distinction is a particular bit of folk psychological wisdom that the law makes part of its criteria right. So, for instance, we say people are presumed to intend the natural and probable consequences of their action. So if I'm charged with intentional murder and I put a bullet right in somebody's heart at point blank range, the jury is entitled to presume that I intended to kill them. It could be that we less often actually do intend the natural probable consequences of our actions than people think. Could neuroscience conceivably help us figure out if that's true or not? Maybe. And if so, that doctrine ought to be altered. But then comes the question, if the criteria in law are moral, who should be excused by reason of legal insanity? That's a moral question, and it's a legal question. And then the only thing that neuroscience or any other science could do for us would be to tell us something about human beings behave, to see if our doctrines are realistic given what we know about human behavior. If they're not realistic, to alter those doctrines to make them more realistic. But what the science can't do is tell us how to live together. That's for us to decide, not for scientists. They can tell us about us, they can teach us everything about us that they know, but they can't tell us how to live together.
It sounds similar to what I'm about to say. At least you make me think this by what you say, that we don't want to bring neuroscience in to tell us how to do justice, but as we do justice, we want to make use of whatever is available that seems useful and true about the science.
Perfect.
The difference between guilt and sentencing. If a person is guilty, then do they deserve the fullest range of the sentence possible? Or what's the difference between a lower sentence and a greater sentence once guilt is established?
Right. Everything depends on what your purposes of sentencing are. At trial, we determine, is this person culpable for committing this bad act? In other words, did they meet the legal criteria for the crime, and did they not have a defense, like legal insanity or duress or something of the sort? So if they met the criteria for the crime and they don't have a defense, they're guilty. Now comes the question, how should society respond at that point? And sentencing has many different purposes. And this is a social judgment. What should be the purpose of sentencing? So one of the things you might say is, what sentences should do is to give people their just deserts. It should give them what they deserve. Now, I don't mean revenge. I mean a theory of justice, that people deserve things, both praise and blame, punishment and reward for what they've done, if they did it responsibly. Then you have to decide, okay, how much does he deserve? If there are no mitigating factors, you're going to give him towards the high end of the sentence. If there are mitigating factors, you're going to give him toward the lower end of the sentence because you're trying to calibrate to what he deserves. Okay, suppose what your goal is social safety. And now what you believe is, although he's guilty and has no mitigating factors for various reasons, he's not likely to do it again. You might want to let him out earlier, as opposed to giving him a longer sentence. On the other hand, how about general deterrence, using the law's punishments to scare the ordinary citizens not to do these things? Really serious crime, you might want to jack up the penalty, even if you think somehow he deserves mitigation. And you can blend all three of those concerns. Everything depends on the social judgment. And that's something science can, now science might help us with, is he likely to be a danger in the future? Is he likely to be a successful recipient of a treatment program in prison? Science might help us with those things, but it can't tell us ultimately what sentence is, in justice, the right sentence for this particular defendant.
So is it not a mitigating factor that your brain is not fully developed and you're liable to act more impulsively?
Well, the Supreme Court thought it was a mitigating factor, but the reason it was a mitigating factor is because you are impulsive, not because, and it's not your fault that you're impulsive, but it could be not your fault for reasons not having to do with developmental immaturity. It could be, again, having to do with characterological things or your childhood training or whatever it was. So impulsivity looks like, if it's not your fault, it looks like a really good mitigating factor because what it does is it really impairs your rationality. When we're impulsive, we're not at our best typically. You know, we're thinking only of short-term consequences, not long-term consequences. We think without, we act without thinking and stuff like that.
Everybody experiences this.
Everybody
Who says,
experiences
I gotta have that piece of chocolate.
Exactly. Exactly. And, if you are impulsive, it seems to me your rationality is impaired, at least in those conditions in which you are impulsive. And that, to me, ought to be a good mitigating factor because think about the insanity defense. The reason we're mitigating people who are legally insane is because they're not capable of rationality. That's why we don't hold responsible or hold to be legally incompetent people with severe dementias. Young children, we don't hold responsible, not because they don't act intentionally, it's because we think their rational capacities are not yet fully developed. We set a bright line at 18. Now, what we know, of course, is some 25-year-olds look like 13-year-olds and some 13-year-olds look like 25-year-olds. But that has to be assessed behaviorally. Because an 18-year-old who's really immature, I don't care why he's immature. He is immature. And if, we can show that he is, so even if his brain is or is not yet fully developed, it's behavioral. Then you have the question of what do we need to do with these people for social safety? So let me give you an analogy. We have in 20 plus states now what they're called by different things, mentally abnormal, sexually violent predator commitments.
That they're committed to this. Oh no, what are the commitments?
They're committed to a forensic hospital.
That kind of commitment.
And so here's how this works. Here's how this works. You've been convicted of a sex crime. You've been held fully responsible for it, and we've punished you as much as we want to, and as much as the law allows. Now, at the end of your prison term, because we think you're still dangerous, we civilly commit you.
Oh, right, yes.
And the Supreme Court has held this practice constitutional. In fact, many of us are strong opponents of this. What you've raised is the wedge that's always driven between social safety and culpability. Many factors that reduce responsibility, roughly speaking, also make the person more dangerous. And impulsivity is a classic example of that. So now imagine a death penalty case. And the defense says, look, my guy's impulsive, his rationality is impaired, therefore he doesn't deserve the death penalty. And the prosecutor gets up and says, yeah, he's impulsive, he's going to kill somebody again. He's dangerous, you better put him to death. Yeah. So you've got that classic wedge.
Makes it hard to make that a defense.
Well, that's right. That's right. And in fact, a lot of people thought neuroscience was going to be a great boon to the defense bar in capital cases. It was one of those things that looks like, we don't have enough evidence yet to know for sure, but be careful what you wish for. Because that same hole in the head that suggests he's less responsible also suggests he's going to do it again.
Let me ask you something. With all of this happening in neuroscience, and with your saying it's not there yet, what would you look to that would be helpful to the justice system for neuroscience to come up with? What would you look forward to from neuroscience?
Okay, let's start with what I think is the easiest question first, where I think neuroscience could conceivably be most useful. And I'll stick to criminal justice, because you're dealing with a criminal case. The criminal justice system makes predictions of future dangerousness all the time. How long should this guy's sentence be? Is he safe to release on parole? These are all predictions. Should this guy be committed as a mentally abnormal, sexually violent predator? That's going to require a dangerousness prediction. We now have behavioral tools for making the predictions. They're not terribly accurate except in the most extreme cases, but they're way better than chance. Wouldn't it be nice if we had another tool to make these predictions more accurately? Wouldn't that be a more just system? And I think the answer to that has got to be yes. So the question is, can neural markers, as it were, neural variables, help us make these predictions more accurately than current behavioral techniques? And can they do it in a cost-justified manner? As the neuro gets easier and cheaper to obtain the neuro data, gets easier and cheaper to obtain, I think it might very well help us make more adequate predictions in the future, and that would be really good. Now, let me just finish one more thing about this. A lot of people are concerned, I'm afraid if we get too good at predictions. But here's what I can imagine. What rational argument would suggest that a practice we already think we're justified in engaging in, making these predictions, so we already think we're justified in making these predictions, what does a good argument sound like for doing it less well? Well, we can do it better.
Right. Now, let me make sure I understand what you're saying.
Right.
When you talk about making predictions, are you talking about based on what's going on inside the head that we can see with pictures, we can predict someone's behavior to some extent? Is that the kind of prediction you're talking about?
Yeah, and notice the reason
this person has a tendency to do this bad behavior.
No, here's what we know. We know if you see a certain pattern of activation on a certain task in the scanner, for example, that pattern of activation is associated with a higher risk of future offending. Now, again, the reason this is, I think, the easiest problem that neuroscience might help us solve is because it doesn't require us to understand it theoretically at all. We just note that there is a statistical association that helps make the prediction. We may have no idea why that activation creates the risk, but we just know it's associated. So it helps us make the prediction. So that's the easiest case. Trying to figure out things like, did the defendant intend, or things like that, those are years and years away if we can make progress at all compared to just behavioral assessment.
The reason why some people would be afraid of the prediction that neuroscience can make is that you would put somebody away before they do something?
No, that is a fear of some civil libertarians as well. Why not just scan the population and take prophylactic measures? But let's assume we only did it with people that we had reason to clutch in the criminal justice system already. I think people are afraid that this is in some sense a civil liberties problem. But I don't think it is, because again, once we've decided we have control over this person and we're justified in doing it, and we're justified in using predictions to decide on questions like how long the sentence should be, when a person can be released early on parole, then it makes all the sense in the world to do it more accurately. How can it be unjust to do it more accurately if we decide it's just to do it at all?
You make me think of something I read that you wrote once about the difference between cause and responsibility.
Oh, yeah.
Can you explain that to me?
Sure. Many people think if you identify a cause for crime, something that played a but-for role in the crime, it would not have happened but for this part of the causal story. And everything we know is only a partial causal story. They think somehow that behavior has got to be excused. But that's to misunderstand the basis for excuse. Causation per se, whether it's biological causation, psychological causation, sociological causation, astrological causation, I don't care. Causes are not excuses. We're all caused all the time. If causes were excuses, we don't know the causes, but we are. At least we think in principle we are. This is a regular, lawful universe, including human beings. So if causes were excuses, no one would be responsible ever. If you look at the excusing conditions
This is, by the way, probably the biggest stumbling block to bringing the MRI into the courtroom.
Well, yeah.
Because then doesn't everybody get off?
Well, no, but for all sorts of reasons I could explain in a minute.
Okay.
But if you look at what the law's excusing conditions are, even if you committed the crime, you met the criteria of the crime, I killed somebody intentionally, the excusing conditions, and now I'm going to be very rough, are lack of rational capacity, think of the insanity defense, or compulsion. Someone sticks a gun at your head and says, do it or else, and it is a crime.
Puts a gun to my head and says, shoot that lady
Or I'll kill
shoot you.
Exactly.
So now that gets me off?
Well, in many jurisdictions it does, or it might. It goes to the jury. That's called duress. So basically it's lack of rational capacity and compulsion. And by compulsion I mean metaphorical compulsion. Notice, I didn't pull your arm and pull the trigger finger for you. You did it intentionally. You just did it under an enormous threat. You were coerced to do it. Okay, so here's where causal information is helpful. Causal information is helpful to us figuring out whether or not someone really was irrational at the time of the crime, or perhaps was compelled, especially if they're making an internal compulsion claim. You know, the pedophile, I couldn't help touching the kid. The drug addict, I couldn't help seeking and using the drug. But just because I can show brain causation does not mean I'm excused. You have to show, you have to translate. Again, the folk psychological criteria, you always have to translate the neuroscience, which is purely mechanistic. Neural networks do not have hopes and aspirations and mental states assessed past, present, and future. They're just pure mechanisms. You have to translate that purely mechanistic stuff into the law's criteria. So the question for neuroscience and law always is, here's the legal question we're trying to answer, whatever it is. Show me precisely how that bit of neuroscience data helps me answer that question. That's always the question. Translate for me. Show me how this bit of neuroscience data, this bit of brain or nervous system data, answers my legal question. And if you can't show that legal relevance, the neuroscience may be great science, but it's not useful to the law. And at present, my view is most of what we know is not terribly relevant yet, maybe in the future. In fact, I think it will be in the future.
If there's a big boulder at the top of a hill,
Right.
and I give it a push and it rolls down the hill, I've caused the boulder to roll.
Right.
The boulder's not in a position to be intentional about rolling.
No, it isn't.
But it still sounds a little murky to me when somebody's under the influence of friends, or somebody has a brain similar to an 9-year-old who gets furious, this particular 9-year-old, when somebody crosses their eyes at him
Right.
and he slugs them in the face.
Right.
And some people maintain that trigger, that trigger happy
Yeah.
approach for a long time. So it sounds like there's something going on there that is causal.
Well, there is
that ought to
something
be, ought to be taken into consideration.
You almost got it.
Okay, help me out.
Look, something is causing you to have this conversation with me,
Yes.
but you're fully responsible.
Yeah.
Look what you set up as the potential mitigating or excusing condition. It wasn't the brain. You told me a story of a person with a lifelong characterological problem that leads them under certain circumstances to act first and think later. The question, whatever causes that, whether it was their mommies and daddies' behavior towards them as kids, whether they have a genetic endowment, whether there's a gene-environment mix, whether it's a neurotransmitter problem, whatever it is, the real question is, should that kind of hair trigger character, should that be a mitigating or excusing condition? Now, if there's a question whether the person has a hair trigger personality, and it's an unclear case, then the neuroscience or any other science might push us one way or another. But in those unclear cases, we're probably not looking at much of a mitigating condition.
Well, and then there's the other problem of if a person has that hair trigger thing, shouldn't he be held responsible for it? I mean, you let that person wander around.
Well, not necessarily. What you might say is, let's assume you're more tender about these things. So you decide, okay, this person is less responsible because they're not in rational control of their response under certain circumstances, and frustrating circumstances arise in every life. The only way you can avoid it is to, lock yourself up in a cork-lined room like Proust or something of the sort. So, okay, it's going to happen. He may be less responsible at the time it happens, but he's also very dangerous. And our society is always trying to figure out, this is once again the social safety culpability wedge. We're always trying to figure out how to navigate between those two desires, to do sort of culpability justice on the one hand, and to do social safety protection on the other hand. So, at present, the law does not take that into account. It may at sentencing, but it certainly doesn't at the guilt phase.
If a child
Yes.
does it, then you would automatically assume, based on the folk criteria you were talking about, that we just take it for granted that the kid just couldn't think his way through it.
There have been special rules for kids before we had any kind of imaging. There were special rules for kids in the common law back hundreds of years. And the juvenile court is a product of the late 19th century. I mean, we knew, as the Supreme Court, or as the American Medical Association brief opened up in its amicus brief in the Roper against Simmons case, kids, adolescents are different from adults. Everybody knows that. We knew it all along. We knew it behaviorally, and that's what counts for the law, the behavior.
So neuroscience did not contribute to that, or did
Well-
it give a rationale for that folk criteria?
Yes, it used largely, basically what it said is the criteria for responsibility, and now I'm a rational reconstruction of the court's opinion. Kids are on average, late adolescents are on average less rational than adults. Therefore, they're less responsible. Therefore, as a class, we think they do not deserve the death penalty. In that first case that decided that, they did not cite neuroscience directly. They cited common sense and they cited behavioral science, which in my view was right. There was an indirect reference that some people think was to neuroscience, but it didn't mention neuroscience. In Florida against Graham, the case that decided whether it was constitutional to impose life without possibility of parole for non-homicide crimes, like rape and burglary, on juveniles, the Supreme Court did cite neuroscience, but they cited it very, very generally. They didn't cite any specific neuroscience, and they cited it in answer to a claim that no one had made. They said, nothing since Roper, that was the death penalty case, nothing in the science of adolescent development has changed that bears on the question of juvenile responsibility. And then they cited neuroscience as an example, but no one had said it had changed. So it's what lawyers technically call dictum, not part, in my view, not part of the rationale of the holding.
The whole question of revenge, you haven't really dealt with revenge
because I don't think revenge is a justifiable aim of the criminal justice system.
Yeah, I mean, I really wanted to hear
It
about
isn't.
that from you.
It isn't. I mean, what the criminal justice system should be doing is justice, not bloodlust satisfaction.
It wouldn't surprise me to have somebody come up with the idea that the justice system, although dishing out just desserts and protecting society from repeat offenders, is getting a bit of revenge in both of those processes.
Yeah, there's no doubt that people feel vengeful feelings, but what we don't want is our law to instantiate revenge, because that's not justice. And what we're hoping is that what we've done is come up with an appropriate, measured, proportionate response with all criminal sentences, not just the death penalty. Now, some people say, well, the law prevents vigilante justice. So the whole point is, we're going to do revenge for you. But I don't think that's right. I think if we don't want people to do vigilante justice, we make vigilante justice a crime. The law should do justice. It should not do revenge. Retribution is not revenge. That's often mistaken. Giving people their just desserts is not revenge. It's a theory of justice. And unlike many critics of retribution who think if you're a retributivist, you necessarily must be harsh in your penalties, you can be a retributivist and tender. You believe that most people don't deserve very harsh penalties. And you might be a retributivist and believe nobody deserves death. So there's nothing about retribution as a theory of justice that commits you to being harsh or punitive. It just commits you to thinking one justification for punishment, one. If you're a pure retributivist, it's the only one. If you're a mixed theorist, as I am, it's part of the frothy brew. One theory is you give people what they deserve. That's part of our moral practices.
Brain overclaim syndrome. What kind of a syndrome is that?
Well, I'm kind of a wise guy, and I'm always making up these new syndromes to describe ways that people behave in the justice system that I think don't make much sense or are not rational or not ready for prime time. So there was what I called a lot of neuro-law exuberance starting around 2000. Irrational neuro-law exuberance. The neuroscience is going to change the justice system. It's going to make it kinder, gentler, greener, and everything else in the world. And Roper against Simmons, people said, oh my God, the court's finally going to cite the neuroscience. This was 2005. They're going to cite the neuroscience. And I took the position, it's just not so. That these people are making vastly overinflated claims about what neuroscience can really do for us today. Remember I talked about legal relevance before? Most of what we know today, and I don't know what's going to come out of the laboratories tomorrow, but most of what we know today is scarcely legally relevant. So you have all these people in neuroscience and in law, because lawyers are always looking for the newest tool to help us out, who are making these exaggerated claims about what neuroscience can do for us, and I accuse them of suffering from brain overclaim syndrome.
Claiming too much?
Claiming too much based on what we know today, and I actually recommend a therapy for it.
What's that?
Cognitive gyrotherapy.
How does that work?
That works by learning more about what the legal relevance really is, understanding the law better, and understanding that you don't have much of an answer to the question, what is the precise legal relevance of that bit of neuroscience data?
I would imagine that their position is something like, but it ought to be more relevant legally if we know this stuff about the brain. It may not be relevant now, but shouldn't we have a broader view of what's going on in people's heads if we want to really assign blame where blame is due?
Well, the answer is it might. It depends on what our moral concepts of blame are. If we learn things about human capacities that suggest our practices are unrealistically harsh, or we expect things of people they
Or
are
not useful, not just harsh,
And
but
not useful.
Don't really lead to a better society.
Okay, don't lead to a better society, then we would have reason to change. But what if we learn in neuroscience that what we're doing morally and in terms of usefulness is about as good as we can do, as well as we can do? In that case, we'd have no reason to change anything. It would be interesting information, but we'd have no reason to change anything. And think what it would take when we have practices of living together that are based on moral reasons that we have reason to endorse, and that are based on long experience of human beings as we know them. Think what you'd have to show to cause some radical transformation. And that would be a very tall order, and neuroscience is not there yet, which is why I say brain over claim. Let's see what comes out of the laboratory. Let's see what its relevance is to our legal and moral concepts and practices, and I'm always open.
Well, you're in a wonderful position to evaluate what's coming out of neuroscience because you've studied it
Yes.
in detail.
Yes.
Has the rest of the legal profession done that? Are they in the position to evaluate how useful neuroscience might be to them as it develops? Not now, but not necessarily now, but as it gets more and more profound and gives us greater insights into the brain, is the rest of the legal profession in a position to make use of those good changes?
Well, not yet, because it really requires two things. It requires an adequate understanding of the neuroscience, including its limits, and it requires an adequate understanding of law. Now, the law professors and lawyers obviously understand the law pretty well, but they don't understand the neuroscience very well at all, which leads them to make the inflated claims. And on the other side, the neuroscientists make inflated claims because they don't understand the law.
Right.
So, for example, here at my university, the University of Pennsylvania, we have a Center for Neuroscience and Society, and every summer we have a 9-day boot camp, which is intensive training in the methods and the infrastructure of neuroscience for people who are not scientists, who want to learn about it to use in their own professions. And a very significant number of people who come every year are law professors and lawyers. And what we're hoping is to develop a body of people out there who will actually be in a position to understand it, or at least understand it well enough to understand if it genuinely is legally relevant.
This case could be an example where the defense says, my brain made me do it, don't blame me. What would be your response to that?
Your brain made you do everything. Because the brain is always involved in the causation of your behavior. The only way the brain is relevant is if it shows us that a genuine behavioral excusing condition was or was not present. But the brain is always part of the causal explanation of all behavior. And again, if you're behaviorally okay, I don't care how bad your brain looks. And if you're behaviorally not okay, if you're psychotic, and obviously psychotic, I don't care if we can't find anything wrong with your brain. You're an irrational person, and you may not be responsible for what you've done.
So in a way, our brains are always on trial.
Of course.
That's what's on trial.
Oh, well, always. I mean, you know, if your brain is dead, you're dead, and you're not of much legal interest at all.
Except for the will.
Except for the will.